introduce the members of the board and explain the procedure that we're going to be following in a moment. If anyone is here to attend the Cochise County Board of Adjustment hearing, which is scheduled for 6 p.m., it has been set over into Building E. So, now you know. First, let me introduce the members of the board. To my far right is Tom Patterson. Immediately next to me on the right is Melissa Harton. To the left is Peter Gunlich, and on the far left is Michael Norman. The purpose of this hearing is to decide an appeal in which it's alleged that an error was made by the Design Review Board in an order or requirement or decision that it made. After hearing the testimony of witnesses and examining exhibits, this board then will decide whether the appeal, the decision, of the DRB should be affirmed, reversed, or modified in some way. Now, there are 3 issues before the board. The first issue is to determine whether the DRB wrongfully permitted or approved revision of a window placement due to an interior wall change at the address that I mentioned. The second issue is whether the DRB basically wrongfully permitted or approved an exterior staircase added to the home. And the third issue is whether the DRB wrongfully permitted or approved reduced setbacks on the north and east sides of the house. Other issues were appealed. There were numerous other issues. But they were appealed more than 30 days following the decision of the Design Review Board. The zoning code is very explicit in saying that an appeal must be filed within 30 days of the date that the Design Review Board approves an exception or a variance. If it doesn't fall within that 30 days, then this board loses jurisdiction, which means we do not have authority to hear the case. Now, the hearing tonight is what's called a quasi-judicial hearing. It's sort of like a trial, but it isn't a trial. We will have witnesses testify, and you'll notice this is not a courtroom. So the first witness or the first party to go forward will be Mr. Sky, the applicant. If you go over to the microphone over here when he's talking, and he will be allowed to be questioned by Mr. Laird, or whoever the representative is for the Laird Family Trust. We have a microphone over there at the end of the counter where I'd like that person who's ever questioning the witness to stand, because we need to ensure that your testimony is being picked up on tape. Now, each party is allowed 1 hour in which to present their case. This will include the testimony of witnesses, questioning by the opposing party, questioning by the board, and closing arguments. So you need to watch your time frames fairly closely if you're going to be presenting a lengthy case. Now, the board may take a recess after the applicant presents his case. It may not. In the event that the board does take a recess, please don't talk to the members until after this matter is heard and a decision has been rendered. Mr. Sky, being the applicant, will be able to testify first. He'll be able to call whatever witnesses he wishes to have to speak for him. He'll be able to be asked questions by the appellant, who's the large trust, and then the board may have questions. After Mr. Sky has presented his case, eventually then the large trust will be able to present their case, and the roles are simply reversed. And we're worried about decorum. I understand that this matter has been hotly disputed. I expect the parties and all others here to respect the proceedings and to respect each other. And anyone who is disrupting the hearing will be asked to leave and will be escorted out if necessary. Continuing with the agenda, call of the application, which I've just been going through, and we will have a summary of the issues and relevant data by the city planning staff.
Chairman Nelson, you did touch upon why we're here, but just briefly, there was an appeal to a DRB decision. Those are the 3 items that were identified. Those were modification requests. Here's a list of the materials that have been provided to each of the Board of Adjustment members. And each of these items is available. We do have an electronic PDF copy of all of the items that are available for review if requested. DRB application 1824 for the May 8th meeting, DRB application 1824 for the May 23rd meeting, DRB application 1824, which was modifications at the September 5th, 2018 meeting. We have the Bisbee Zoning Code Articles 2 through 6, which are applicable to the appeal. We have the Bisbee Historic District Design Guidelines. We have Bisbee Adopted Ordinances 01712, 01717, 01803, and 01809. A current aerial map of the Laundry Hill area, the Historic District Overlay Boundary Map, the action agenda for the September 5th DRB meeting where those modifications were heard, ARS, Arizona Revised Statute, Section 9-462.06, discusses Board of Adjustment. We have the Laird appeal with Bates numbering. We have the applicant supplemental combined documents, the appellant supplemental combined documents, and the Laundry Hill record of survey. Again, there are 3 applications, and this is cumulative as to the drawings and photos that were submitted as the application progressed. Here is a historic district map of the Old Bisbee Historic District, and identified toward the center, lower center, there is a bubble there that shows the approximate location of the Mr. Sky residence. So clearly within the boundary, the dotted circle dots are the boundary of the historic district, so clearly this lies within the historic district jurisdiction. Here's an aerial photograph that was taken Monday of this week that shows the approximate area of Laundry Hill. I have a zoom in of the same photo, which is showing, you can see the direction north is pointing up, and I did date that. So again, just for the board to be able to look at the characteristics of the neighborhood. And then this is a record of survey. This survey was from May of 2018 and was really the basis for a transfer city property, but more specifically it does identify that the 2 parcels that are colored are the subject parcels. The Sky residence lies across both of those parcels, so that is available as well. And Chairman Nelson, that would conclude the staff presentation.
Thank you. Next matter is the presentation by the applicant, John Sky. Is Mr. Sky present?
Yes, sir.
Mr. Sky, if you'll go over to the podium over here. Raise your right hand and you swear you in. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, spell your last name, please.
My name is John Sky, Jonsky. I'm a resident of Bisbee all my life. My wife as well. Both my kids are born and raised in Bisbee. I decided to fix this old house the beginning of the year. I wanted to make a place for both my children so they'd have a place to live, you know, long after I'm gone. Let's see here. I guess you know, I'm just I've been running around trying to fix as much stuff in the town as I can. I was pretty much hell on wheels when I was younger, and now I'm trying to give back to the community instead of just taking away. This is pretty simple. I believed from talking to the inspector, all the design review board people, anyone that I could talk to, that I was doing things the way that I needed to do them. Tried to follow all the rules and regulations. As far as the setbacks go, I was told that I could rebuild the house in the same footprint because it was already there, even though it was in close proximity. But every house on the hill is in close proximity. Everything is built on or beyond property lines up there. So it, you know, goes along with what's already been up there. So that's what I was doing, is following the characteristics of the neighborhood. I just got the city parking lot today, so that takes a big part of the easement away. The reason that I had to put the stairs in was a safety issue. It was a code issue. I never really intended on doing that, but you know, I realized that when I was going to put the staircase on the left side of the house, but it wasn't going to work out, and then there was so much problems with encroachment issues and things like that, because originally I had an agreement with the Humphreys, and we were supposed to work with each other to make these things, you know, make everything work out so we could all be happy. That quickly turned south. I actually helped the Humphreys encroach on the house that I bought. I built a wall. It used to be a 2-foot walkway there. Now it's a 9.5-foot walkway. So they literally have a 9.5-foot walkway in between my home's walkway and their home's walkway. So literally, there's no taking. I haven't taken anything from them. They could drive a quad down their walkway. I, on the other hand, cannot. I tried to build the house exactly where it was in the same footprint and then just run it back. As far as I understand, I'm not going to start digging through this. I guess I can do that later. The window placement, it just made sense because the design review board didn't want me to put in a door. There was a door change, so all we did was just shift the windows due to the door change for aesthetic purposes. That wasn't anything that I really wanted or didn't want, but I'm obviously okay with. I tried to work with the design review board as much as I could. I mean, essentially the design review board designed my house. I just kind of came in here with some ideas and then asked them what they thought I should do. They explained to me what they thought I should do, and that's what I did. Other than that, I worked directly with Joe Ward, the city inspector. I went through every code, made sure that every single code for building was done. There's nothing that's not up to code on that house whatsoever. It's up to current code. The only issue that anyone could talk about is the setback on the east side. But given that the house was already closer than that to begin with, I believe that it's a grandfathered situation. And as far as the walkway and the porch there's some temporary decking there that's going to be taken out because the city's actually going to run a city line through my property, and then I'm going to rebuild that in solid concrete because it's can't catch on fire, and that's to bring it back up to code to make just a simple walkway. But I would like to, if I could just call Mr. Budge up here to explain, what's transpired. Is that something that could happen?
You certainly have the right to call any witness that you desire.
Yes.
But before you do that, the Laird Trust may have some questions of you, and the board may have some questions.
Okay.
Who's speaking for the Laird Trust?
I
You will hear, sir.
Thank you, sir.
Identify yourself, please.
Yes, my name is Brian Laird, and I represent the Laird Trust and the Bisbee Trust, which are the appellants in appealing from the DRV's decision. Thank you. Mr. Sky, you said that you built in the same footprint as the existing house, correct?
That's correct.
Okay. In fact, what you did was you began in the existing footprint, and then you brought it north up Laundry Hill toward the road
Yes, sir.
about 17 feet, right?
Yes, sir.
17 feet past where the old house was, correct?
Yes, sir. That was the addition.
Okay. And the construction that you have now, the building that you have now, is that a single-family residence or is it a two-unit structure?
It's a single-family residence.
Okay. In order to build, so do you call it a home?
It's a single-family residence. Me and my family will be moving in there, so I don't...
Okay. If I call it the home, will that be, you'll understand
Sure,
what I'm
that's
talking
fine.
about?
Yeah,
Okay.
It's my family home.
Okay. So in order to build the home, you built a foundation, correct?
Of course.
And that foundation runs the entire length of the home, correct?
Yes, it does.
It's underneath the home and it supports the entire home, right?
Of course.
That foundation is made of concrete posts, is that right?
Yes, reinforced steel and Samson tie brackets for the beams that it sets on.
Okay. So that's a brand new foundation, correct?
It is.
Okay. And on top of that brand new foundation, you have brand new joists, correct?
I used a lot of recycled material and stuff like that, but yes, I replaced the whole foundation due to the fact that the existing structure I was unable to salvage it to keep things up to code.
Okay. So you got new joists, you've got new floors that are above the new joists, correct?
Yep.
You've got new walls, correct?
Yes.
You put up framing for those new walls, correct?
Yes, sir.
New siding around the whole thing, correct?
Yeah, it's a custom siding that I made, hand milled.
Okay. And in fact, that siding runs vertically as opposed to horizontally, which was how the siding appeared on the old building, correct?
Yeah, the 1x12 siding, it's pretty well known around town as board and batten.
Okay. And you've got new windows
I do.
Throughout
Energy
the-
efficient, up to code.
throughout the whole home, correct?
Yes,
Okay. New doors, correct?
yes,
You've got new decks
yes.
around the whole structure, right?
Not the whole structure.
Okay, on 3 sides.
Yes,
Okay. Not on the north facing toward Laundry Hill Road, correct?
yes.
And you built all of those decks from lumber did you salvage that lumber?
A lot of it was salvaged, and what I came up short on my salvage materials, a lot of the windows and doors were salvaged too. I'm definitely into reusing and recycling.
Okay. You also built the stairs new, right?
Yes, I did.
Okay. And the old building that was there before, that was Kendrick's home, is that correct?
Yes, it was.
Okay. And Mrs. Kendrick's home, the roof line ran east to west, correct?
Yes, it did.
Okay. And your new home, the roof line runs north to south, the opposite direction, correct?
Yeah.
Okay. Is this the first new home that you've built?
I've been involved in many projects around town, a lot of rehabilitation projects, and, you know, fixing up homes and stuff. Just this house ended up being a little bit more than I thought it was going to be.
Okay. You said that you had followed every code, correct?
Yes, I did, absolutely.
Let me see. Were you aware of setback requirements for a new home when you built the home?
I was told that because everything on the hill was built on or beyond property lines, that it went with the characteristics of the neighborhood and that it was okay. All of this information that's come out later on was unbeknownst to me when I started building the foundation, etc.
And who told you that?
Numerous people, inspectors. I talked to design review board people. I talked to other people that were in construction around town, other contractors. Pretty much anybody that I could extract information from due to the fact that I'm pretty new at this type of thing.
Okay. Your initial application and each application after that, you sought, well, your first two applications, you sought to build an addition onto the existing home, correct?
Yes.
And in fact, that addition was to be to the south, right?
Dyslexia. I got my north and south mixed up. It was an honest mistake, which they rectified that situation in the design review board meeting. If you go back and listen to the tapes, you understand that.
Okay, and as we look at this photograph that's behind you, to the south would be away from us toward the mountains, across the canyon, toward the highway, right?
Yeah, which wouldn't make sense to try to build out that direction, and it definitely would have, hindered. It would have been way too hard to do that, so that was never my intention.
And that south direction, that would be toward Tombstone Canyon, right?
Yes, it would.
Okay. And you were aware when you submitted your application that you were applying to build toward Tombstone Canyon, away from Laundry Hill and the other houses on Laundry Hill, right?
No, towards Laundry Hill is what I always intended to do.
Okay. And you also, at the time you filed your initial application, you filed for, requested, and were granted a demolition permit, correct?
Yes, I was.
Okay. And that was, in fact, your intention was to demolish the old house and build the new house that you built, right?
Absolutely not. What ended up happening is I pulled the roof off, and then I asked the city inspector if I should just cover the siding with OSB or plywood and then start from there. And I was instructed that it would probably be better to take off the siding carefully, which when I started to do that, we quickly realized that it was made of 2x2 construction. It was a kit house. It was essentially built like a trailer, except for what Kit Hendricks had done is the roof had been leaking for so many years that there was plastic coming down from the ceilings to catch the water from coming into the house. But what was happening is the water was just running directly into the wall cavities and running down all the way to the foundation and into the joists. So once I opened that up, it was determined that the framing was definitely not any good and it had to be reframed. And then there was already a 10 by 20 hole cut out of the floor and the floor joists and stuff. So the floor was already going to need to be replaced. They had dug a 4-foot deep, square directly under it for some reason, I don't know. So the floor was already going to have to be replaced. And then when we started looking at the concrete, the structural part of it, the concrete would literally crumble in your hand.
Was all of this during May of 2018?
I can't really recall. It was directly after I had the permit when I started doing the work.
Okay, so I just want to make sure, everything that you're describing, that all came after you applied for a permit to demolish the existing building, correct?
No, to demolish the roof, siding, pull the rotten windows out. It was kind of it was a chance to get a look into the structure of the house, which didn't end up very good.
Did you know all of those issues existed, and that the house had to be completely demolished and replaced with a new structure by May 28th of 2018?
Absolutely not. It was a full remodel, rebuild.
Well, okay, I'm not asking whether it was a full remodel, rebuild. I'm asking if by the May 28th, 2018 DRB hearing, you knew about all the problems that you're describing that were going to require new foundation, new joists, new walls, new building.
Absolutely not. I wouldn't have bought the house if I had known that, because I personally am very anti-demolition of historic homes.
Well, I'm not talking about when you purchased the house. I'm
Well, I
talking
said
about
absolutely not.
I'm talking about the May 28th DRB meeting. Okay, so
Absolutely not.
okay, that's all I have. Thank you.
Mr. Sky, do the board members have questions?
Good evening, Mr. Guy. Question I have is, can you walk me through the process that you went through after you discovered the problems with the house and decided you needed to rebuild it and redo the foundation and redo it from the ground up?
Yeah.
And, you know, I'm interested in the setbacks and kind of, you said other people have told you can just use the same footprint as the old building and that sort of thing, and that you worked with the design review board. Can you kind of walk me through that process of how, once you discovered that it was going to be a major project more than just the remodel, how you did your planning and how you came to the decisions on the size of the footprint and where it would go on the lot and address the setbacks and that sort of thing?
Okay, so the structure was originally 28 feet wide. Let me just step back. Originally, what I wanted to try to do, or what I was intending to do, was to save the little house and then build posts around it to build a top floor, build an addition with the top floor, and tie it all in together. That's what I set out to do. Once we realized that that wasn't going to work out, I took it down piece by piece and got rid of all the problems that it had, and then realized that there was pretty much nothing left. So I cleaned up the whole lot, and then I cut the house back 3 feet, because that was something that the design review board asked me to do, is to shorten it up so it didn't look as wide. And then I just added the addition that I was intending on doing in the back, and then just ran it straight back from where the original house was. So I made my triangle of where the house was going to sit, and then I submitted plans for the foundation, got those through, put the foundation in, then joisted it, decked it, and started building it.
Okay, so I just want to make sure I understand. So when you started, after you discovered the problems with the existing house and you demolished it, you also removed the foundation from the old house. Is that correct?
Yeah.
Did you start with kind of a clean clean lot?
Yeah, I had to fill in the big hole that they had
Yeah.
dug underneath the house. So I filled that in, brought a bunch of fill in and filled it, and then kind of got it, got myself a nice canvas, if you will, to start to try to put the house back in the same place.
Okay. So at that point, did you take like a site plan, a scale drawing to the design review board that showed where the new structure would go within the lot lines?
I don't think that, well, yeah, I have one here that I submitted. I didn't make it in the paperwork because I was gone. But, yeah, I have one that was submitted to the design review board with the measurements and stuff like that.
So at that point, was it evident that you couldn't, okay, I think I have that.
Okay, yeah, you got it.
Yeah.
So,
At that point, was it evident to the design review board that, that you couldn't, that the footprint you had didn't fit within the setback requirements?
I don't believe it was. I know that there's a lot of houses, there's a place down on Tombstone Canyon that just got granted a setback of 18 inches. So, I mean, this is going on all over town. This is one of the charms of Bisbee, is that everything is built on top of each other in close proximity, and that's why it looks so cool. And if there wasn't those big fires back in the day, then there would be a lot more of these.
Yeah.
It'd be a lot more convoluted.
And I think that's a concern, really. That's one of the reasons why the setbacks that are established in the underlying zoning is to, fire prevention actually is one of them.
And I put up firewalls. That actually made the house a little closer to the setback because I did a lot of work putting up firewalls underneath the siding and stuff like that. So, I did all the fire protection too.
So, since the setback issue is something we're reviewing this evening, that means that issue was brought up, I think would it be your third application, modification, or your third review? So, I mean, that wasn't, I guess what I'm trying to say is that usually things like where the structure is going to be positioned on your site, setback issues, those kind of things are resolved before you start building.
Okay, well, this is how it happened. I had agreed to rebuild the house in the same footprint. So, it was obvious that it was going to go on the same line from that corner back there directly back. And that's what I proposed to the design review board, and then that's what I got approved for, and then that's what I did. And then later on, because I don't think that anyone anticipated these problems, and then later on, I guess it was like, oh, well, we better set a variance for the setbacks.
So that was after the fact that they decided that a variance was needed?
Yes. Because originally they were just fine with me rebuilding the home and then adding an addition, but I guess maybe it wasn't really thought about how close it would be.
And was that decision based on rebuilding the old house?
Yes.
Not scraping the site and
Yes.
putting in a new foundation and a new structure?
Yes.
So, okay, I wanted to understand the process because, like I said, usually when you're starting with a clean site
Yes.
and you know where your property lines are, you know what the setback requirements are, you know what your building envelope is, and then you design your structure within that envelope. So it
Like
sounds
I-
like, somewhere along the way, what you originally intended and originally applied to the DRB didn't work out,
Absolutely not.
but there wasn't an adjustment made for kind of a change of direction at that point in terms of your building envelope. Is that correct?
Yes, sir. Yeah, I assumed that, how it all came to be is I was like, well, I got to put this house back where it was, and that's what I agreed to with the design review board, so that's what I did. So, I mean, that's how it all happened. I just, you know, I was trying to tread lightly because of what happened with the house.
Okay, so when you went to the design review board with the footprint of your house, the dimensions of it, and your exterior design and that sort of thing, they approved it. Did they approve the setbacks at that point, or did they?
Yes.
Okay, so they knew that the setbacks were not, that you didn't meet the setbacks with the footprint you had proposed.
Which meeting would you be referring to?
Well,
there was 3 meetings. The
right.
last meeting was the one where we made the setback
Okay.
ruling because of the staircase and
And by that date, where were you at in terms of the construction process? By that, I think that was in September.
I have the framing up.
You had the framing up.
Yes.
All right, thank you.
Questions from other members? Yes, sir.
I want to go back to the staircase.
Yes, ma'am.
In your original
Can you talk into
statements
the-
here. I'm sorry. Got that? Everybody hear?
No.
No, can you lower it? How's that?
Pull it forward.
Green light's on.
Testing.
That's
There
good.
you go.
In your beginning presentation, you talked about the staircase. Let's see where my notes are. You said that the one that you ended up with was not what you intended, and that was due to, rules and regs.
Yes.
Give me a little more history on that staircase, how that ended up, since the staircase is one of the things that we are looking at.
Well, originally, you'll see on the left-hand side, that was kind of a built-out porch deal. And what I wanted to do, there was a doorway there, and what I wanted to do was leave that on there. I actually had to take that off because it was rotting off the house, and I knew that was part of the original demolition application that I put in to take the roof off and take that off. And then what I wanted to do is rebuild it and then build a staircase inside of it, going up to the second floor and then extend it and then have it coming back. But then after taking it off, I was a little hazy about me and the Humphreys have already decided that we didn't get along, I guess. So working with them wasn't going to work out. The original structure is actually built on their property, and then it was built on Rodney Smith's property. Rodney Smith has been very good with working with me. I did some land swaps and stuff like that, and I actually asked his permission to, put the staircase there in the back because he has a little parking area right next to my parking area. So me and him are the only ones that are even close to the staircase.
Thank you.
Other questions?
Is it possible to get a picture of the house as it is? That's what was there prior, right?
Yeah.
There
That's
should,
not there anymore.
there should be some in
I
your
mean,
packet.
that's gone, correct?
That is gone, yes.
Because it, I think to see what is actually there.
Yeah, follow-up questions?
No, I just think it's talking about this structure. And they're looking to see what we're talking about as opposed to, the other structure was demolished, correct?
That's correct. Mr. Norman?
Yes. So the staircase that is in question is the one that's shown in the picture there?
Yes, sir.
Or north side? Okay.
And basically, so the original house had a door on either side, on the east and the west, and I was trying to keep that alive in the house, but after we had to do the staircase change on the east side, I wanted to put a staircase somewhere else. So that's where we ended up coming up. And they gave me the permission to build the deck just a little bit longer and then put the staircase down the back. Where the purple car is, that's Rodney Smith's parking space. I built a shared garbage area for us underneath the deck, so it'll be shaded and stuff. And we have easement agreements with each other. So, and then the staircase falls short just right in front of the property that I just purchased from the city of Bisbee, which is 15 feet wide and 22 feet long coming this way. So
is that property that you purchased from the city, kind of where the...
right behind the trailer.
Or behind the trailer?
Well, where the trailer's sitting, it's exactly there.
Okay.
And then
And can I
off
ask-
of that wall, the Humphreys property is 7 feet from that wall over to about where the air conditioning was.
The question, the property you purchased from Bisbee, the city,
Yes, sir.
why did you need to purchase that? I'm just-
I didn't. Pretty much it was an open parking space for pretty much anyone. 10 years ago, Rodney Smith got together with all the neighbors. The city actually owned this piece where the purple car is, all the way back, and then Rodney Smith owns all the property on that side and a house over there, and then around the front of the house. So he went around to all the neighbors. It may have been 15 years ago, I don't know. But he went around to all the neighbors, and then they all worked out deals with the city. Rodney traded the center of the property for the city easement. Then the Humphreys house, which was a lady named Helen's at the time, she bought that parcel of property so she could have a parking spot. And then there were some other people that bought parking spots up the road. But Kit Hendricks was, she wasn't very agreeable to doing anything. So the spot that was here in front of her house, she didn't end up getting because she wasn't interested.
And that was the lady that owned the house that you
Yes,
bought?
sir.
Okay. The staircase, you mentioned that you had to put that in for a code requirement. Was that not identified when you went in for your building permit with your floor plan? And I'm curious, kind of late in when the construction is already in progress, why that was required and it wasn't identified when you went in for your
Because I
building?
added some doors where I was originally going to have windows, and like I said, I had a lot of salvage materials and stuff, so I made some changes throughout the process to integrate the things that I had, because, after all, I'm just a Bisbee kid. I've been here all my life. I'm not rich, so I had to just kind of make work what I had.
Yeah, no, I totally get
So
that.
that's how that all came to be. And then there was some things that I didn't understand because I am pretty new to building my own things. I put in plenty of windows for people that I've worked for since I was 17, but codes are all pretty new to me. They just say put a window there, and then I put a window there. I didn't really know that it had to be a window that you could jump out of. So what happened is I had to put in some egresses so you could get out of the bedrooms.
Okay.
And then that's why there ended up being another, this is an older picture, because in the newer picture you'll see that I had to put a window to the left of this the big window there, because technically you can't run into the bathroom and jump out of that window. You have to be able to jump out of the window from the bedroom.
Right.
So it was just stuff like that.
So, but that wasn't, like, before you started building, you went in for your building permit with your construction drawings. The city didn't call that out, they didn't say, hey, you need an egress window here, or
No,
you need another staircase here. They didn't call that out?
No, because what happened is that, I ended up getting different windows, and then that's when I came back in, because originally I was planning on using a certain kind of window. Well, then I ended up with other kinds of windows that were much better. So I went back, and that's when I changed the plans for the windows.
And you went back to the design review board?
Yes, sir. Got them through there.
Is any part of either the house or the deck built outside of the property lines? I know you mentioned there's...
No, sir.
Okay.
The only thing that could be misconstrued as a deck that is over a property line or outside of a property line is a temporary walkway that I produced only because we were working there and we didn't want people falling in. And then the other issue that will be coming up is the basically below this wall, there's a 4-foot wall, and then it goes down into my yard. So
Is that the wall by the greenhouse?
yeah, that wall runs straight down, and back before I built that wall for them, it went 2 feet close to the house. So this property in the corner here is adversely possessed. There was a fence around it and everything, and that's a civil matter that will have to happen in a courtroom. But the decking that's there, I agreed to Joel Ward that I wouldn't build the decking there. What's there right now is temporary. So as soon as the city comes, I believe they're coming tomorrow, I'm tearing all that decking up because it's all temporary. It's not there, it's not into code, it's
just there while you were working?
exactly, just so we can walk materials back and forth, because things got ugly with the Humphreys, who were fine with me walking down their 9.5-foot walkway to get to my house, but he asked me not to come on his property anymore, so, respecting his wishes, I built another little thing so I could run back and forth and work.
One more question. So as you were building, you put in your concrete posts for your foundation.
Yes.
You had a building permit, right?
Yes, sir.
And did the building inspector come out? Did he measure? Did he sign off on it
Yes.
before you went to the next phase? So
Every single step of the way on every part of the house. Joel Ward was up there probably 2 to 3 times a week. I also had an engineer come and look at the photographs, look at the footings, look at the walls, look at the framing, look at the plumbing prior to me shelling everything, and got an engineer's stamp of approval on that. So, yeah, I hope that answers your question.
yeah, so basically, as you were going along, you felt you were getting the approvals you needed.
Yes, sir.
In terms of the setbacks from the property lines, the city inspector came out and measured and signed off. So then you went on to the next phase.
Yes, sir.
All right. Thank you.
Questions?
Mr. Sparrow, do you have a picture from the other side of the house?
I do not.
Do not.
Don't you have a side view that you put in the packet?
It's a lot easier to see that.
Are we talking about the front of the house?
Yes.
Here's one here, you guys can.
No,
I believe it's in the appellant submittal, right?
Oh, to see if it's up on
So
here.
it can be seen
Okay.
by everyone, but I guess not.
No further further questions, Mr. Sky, you can call your next witness.
Yeah, I'd like to call Kim Budge up to ask him a few questions because he's a lot better at these things than I am.
All right. Mr. Budd? Raise your right hand, please. Swear to tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
State your name, spell your last name, please.
Sure. My name is Kent Budge. Last name is B-U-D-G-E. I was the chairman of the DRB during the September 5th meeting that we were talking about.
Mr. Sky, you're going to be questioning Mr. Budge?
Yeah, I'll ask a few questions and then hopefully he can just run with it so I don't have to act like an attorney this evening. Ken, you've been up to the property up there numerous times to check things out. Is that true?
Sure. So, as part of the DRB, I wanted to explain to you kind of, if you haven't been to a meeting, understand, when an applicant comes before us, we don't normally see a floor plan. That's not in our purview. Now, if we see a window that we don't think should be right, they may say that's a kitchen, so we'll allow an awning window above a kitchen or something like that. So we may get involved a little bit in the interior, but that's really not what comes before us. So we don't really know that when it's presented to us. They do give us a view, and so I wasn't asked to submit anything, but I brought stuff that was brought to me when we made our decisions. So we had a view of the house. We wanted to well, let me go back just a little bit. And John came before us with his first application, but we were told by staff that we could not hear it because the neighbors had not been notified for the 15 days requirement. So we said, okay, but what you brought to us, John, was not sufficient. We wanted better drawings and understanding of the footprint and so on, because the application did say south. So when he came back to the next one, which we held a special meeting between our other two meetings, because it was not only him, but another one that was held up due to the fact that the staff didn't get it properly noticed. Then came the footprint that showed the addition 17 feet, what I believe was 17 feet to the north. We talked about all the different windows. We talked about the decks, what was covered, what was not. We looked at those situations. And then when I looked at the setback, because John, I always go and look at every project before it starts. That's just what I've done for all these years. And if you go back to the previous picture that you had, I wanted to show you something that caught my eye when I went to that particular site, when that old house was still there. It was the old, anyway, yes. And I know it's hard, but if you zoom in, if I had it right there, you'll see a red stake. See that right by the corner of the house? You can see a red flag right there.
It's right in between the wall and the house.
It's hard. I had it. It's right there, right where his hand is. That's the property line. So when I went there and looked at it, that's the property line. The house is about that far off the property line. So when it came before us as a remodel, as what it was, I went with the code. When the code says, and this is 5.3.2 under number 3B, B3, it says that we shall not reduce existing setbacks less than what is required or less than what currently exists. So I went with what was currently existing, which was only a setback that far. And we said you could go ahead and stay on the same footprint as far as width-wise when you extend, because that setback already existed. That was the decision that we made on the original application. Now, I'm not talking about the September 5th, and maybe I'm getting outside of what I should be, but those questions were coming up, so I thought I should address those. As far as the September 5th meeting, what came before us was, and if you go back to the photograph you just had up, it was the stairwell the window, and you'll see the window that we were talking about. Of course, this is all on tape if you want to listen to it. So you see that picture window, it's right above the trailer. That was the picture window that we talked about. The stairwell, he came to us and said to build the stairwell on the east side would be a problem because of the encroachments with the other property owner, because then it got real sticky as things progressed, and said, can I move it to this side of the building? And we said, well, I don't really care where you put the stairwell, whether it be on that side or on, and I don't know if you call this the front of the building or the back, but it's the north side of the building. We allowed a finding of fact to allow the deck on the west side to continue back far enough to catch the stairwell. We required that window that you see there be buffed up so that it's divided in half and put into to look like a double hung. And then what was presented to us was this, which showed the setbacks. Now, hopefully you can bring that photo up. This is what was before us. So when the whole setback issue came about after the surveys were done, we saw that the setback was measured at, or what the distance between the building and the property line was 4'6". There it is. On the east side, and to the street side was 6'3". So the street side should have been 10, and the side on the east side should have been 5 feet, but it was 4'6". This is what was presented to us. I noticed in the applicants that there's now a complete survey, but this wasn't before the DRB when this is what information we had to go on. So we found the finding of fact that a 6-inch encroachment on the side setback was similar in like in the neighborhood, and that the 6 foot on the front was also similar with the garages and so on that were on the street side. So with those three things, we found findings of fact to allow the staircase to be moved, as it would be, we thought, also a less encroachment on the neighbors because it was on the street side. That the window be fixed so it looks more like the window, and finally that the setbacks decreased by 6 inches on the east side and by a little less than 4 feet on the front. I guess that's the way I saw it. John, go ahead and ask anything else.
Oh, you're good. I was just in my head right now. Let me ask Paul, do you have these pictures? The newer pictures that show,
They're in Mr. Blair's.
are they in the packet?
You can put them on.
That was a picture I was
Let me see if I
Just
can
a
show
shows
Mr.
the
Laird.
decks.
And I'm only, because we're looking at some pretty old pictures, and so, let's see.
I'd be glad to submit these to you. I know they weren't submitted ahead of time, but this is what was brought before the DRB. This is his view from the canyon, and this is an actual picture as it was being built on one of the other applications. So if you'd like to look at those.
It's my understanding that the board has been provided with all the photographs that you've been showing us, all the ones that came before the DRB. We have that as part of our packet, as you've been able to look at.
Those came out of my packet.
So I guess I could just ask,
That's right.
as far as you understand, did I try to work with the DRB as much as I could? I mean, do you feel like I was doing anything?
John, it was a exercise as it got built.
Yes.
And you're not the first one. This is a very common situation with us. The little house that was built just above, on Tombstone Canyon, above the High Desert Market. I mean, she came back to us 5 times. And as you get into things, sometimes they come back and say, gee, this didn't work what I originally. And so, yes, John, you came back. We said, okay, we'll allow this, but we won't allow a covered porch on this side. Okay, we'll allow that window, but you have to make it look different than what it is. So it was, you know, you didn't meet Well, what I can say is, we did what we thought was the best design. Once it leaves our hands, it's totally into the city's code enforcement person to make sure what we specified happens. We don't go back out afterwards, and we're not a code enforcement. I don't come out and start to say, well, you didn't do what I said. That's not my job. I'm just a citizen, so.
And then do you remember that my very first application, I came in and then it was forgotten to let all the neighbors know about the addition. Remember the first meeting I came? The reason why I couldn't be seen that time is because there wasn't the notice to the neighbors. And then we ended up talking about the house at that time. And then the next time I came, I brought 2 different sets of plans because I realized that there was a lot of things that you guys didn't like. And then it got really convoluted because then I had 2 totally separate plans.
Well, okay, the first meeting you came, I didn't know until we got there. You were informed that we can't hear it because we didn't get the city didn't get the 15 notification out. That was where it was written South Side Addition, blah, blah. But your drawings were very sketchy and was like,
Yes.
and so we talked about the house and said, John, come back with scale drawings so we know the height, the width, the length, where it sits on the lot. And that's what you brought to us, and that's when we made that big, huge, long meeting about the porches and what was covered and what was not, where the doors were going to go. I mean, this was before any tear down. We were still working on the basis of a rebuild of what you had, and that's what we did. And then you came back twice more for different revisions, as I remember.
Let me interrupt. Mr. Sky, you have about 10 minutes left.
Great.
The time has been allotted.
Let me just ask Brian a
Just a
couple
moment,
things.
please.
Oh, sorry to interrupt.
Mr. Laird has the right to ask questions.
Sure, you want
here,
to?
And the board may want to ask questions. So
Great.
If you're finished, I mean, unless you have some real pressing
I
questions.
can be.
I mean, I just want to make sure
Go
that
ahead.
everybody has an adequate opportunity to participate.
Mr. Budge, were the if you call them decks included in the drawings that you saw, the 2 decks that, and,
The second story decks?
well, there's a deck on the bottom floor?
Yes.
And a deck on the top floor?
Yes.
And do those decks extend beyond the setback requirements, or were they included in the drawing that you approved on the setback?
The drawing showed those, but we were, all we had was the footprint of the house. The decks is not something that usually comes before us, but the setback is not something that, as far as deck, but I know there's a code for that.
Okay, so the setback we're talking about is the setback of the footprint of the house.
Yes, that's,
And the decks that extend beyond that may or may not extend beyond.
yeah, there's another zoning code that has to do with that.
All right, let me, let's let Mr. Laird talk. I don't want to,
Thank you. Mr. Budge, you recognize, you're familiar with zoning code 5.3.2, aren't you?
I would have to look at it. I know, those numbers don't pop right in my head, but go ahead. Which
Okay, well, that's the code on setbacks that we were just talking
Okay,
about a few
sure.
minutes ago. Do you remember talking about that?
Yes.
Okay. And you understand, don't you, that the minimum setback for a new single-family residential structure is not less than the following. The front setback would be not less than 10 feet, and the side setback would be not less than 5, right?
That's number one, and then there's the second part that says we can make a finding of fact, yes.
Yeah. Okay. I'm looking at number 1.
Okay.
You understand number 1, right?
Correct.
And this structure you're looking at up on the screen, that's the north side, that's the front, right?
If you consider that the street side, he considers the front the part that faces Tombstone Canyon. I don't know what he...
It's 10 feet on either side, right?
Yes, so either way.
Okay, same either way. Okay. And the part of the code that you referred to earlier, it doesn't apply to new structures, right?
It applies to additions to structures.
Right. It does not apply to a whole new building like this one, right?
Correct.
Okay. So it didn't have any applicability, it doesn't have any applicability here. The only section of code, as far as the setback goes, that applies to this building is B1, which requires 10 feet in the front and the back and 5 feet on the sides, right?
No, because our first finding of fact, or not finding of fact, when we first considered his first application, was a rebuild of what was there in an addition, okay? So it wasn't a brand new structure. And what that code calls for is currently exists. So what currently existed was a very narrow setback.
Correct. But this is what was built and was in front of you in September.
Correct.
When the frame was up, the roof was up, all of that was up. And this is a brand new structure. This is not a renovation, correct?
Well, that's not the way it never came to us as a brand new structure. If it had been a brand new structure, there would have been a complete, it was brought to us as the DRB from the city as a renovation of an old building and brought back with additions.
Okay, and I think you said that you had been up to the job site several times working with Mr. Scott, correct?
Not working, going up and looking at what was presented to me and walking around, and I checked out neighbors, how far other structures were from.
Do you remember the first time you went to the job site?
Yes.
What was the status of construction the first time you went there?
There was no construction. It was the picture that I showed you with the stake in the ground, with the building about a foot away, and that add-on that was the little porch part on the
Okay.
side.
Did you ever go up there and see it when the foundation was being built?
No.
Okay. When was the next time that you went and saw the building?
Next time he came for another application. It was the third application.
Okay. And you could see that it was a new structure at that point, correct?
There was a lot of new structure, yes.
Okay. Can you see anything that's left of the original building anywhere in the building that's there now?
No.
Okay. That's all I've got.
Board members have questions?
I just get a picture of the deck side of the property.
Can you go to the next one?
Is there a photograph of the deck side? There's 3 decks up there on 3 sides.
This is the opposite view.
Mr. Bud,
Yes.
wouldn't this be considered,
That's
even though there was some confusion in the fact that Mr. Sky was confronted with a lot of challenges at the time, and particularly most people that build in Old Bisbee have similar problems because of the ambiguous property lines and all the other problems that exist. But nevertheless, wouldn't that be qualified as a remodeling and a grandfathered lot? I mean, that's how I would look at it. I mean, he seemed to have been following all the procedures and everything else, and seemed to be diligently attempting to conform to all the rules, and yet I think one of the issues that keeps coming up is the grandfathering of the existing building, of the previous building, as being the template from which everything else was built.
Right, and I'm here to testify to the September 5th meeting, but we did go back and kind of talk about the other original applications. So if that's fair to talk about, I have to do it by the DRB. My job is not to go back out and second guess and do things. We look at what's presented to us. We make findings of fact and say we want this to happen and this to happen. Staff writes that down, and then it's to the city in order to see that those things are followed. So that's what I felt that we've done all along, was he brought, as things occurred and he needed changes, he came back 3 different times. Like I said, it's not unusual. We have many people come back many times, especially on something as big a project as this. I'm not here to justify that it was a complete new building or a rebuild or a tear down or not. That never came before me. I'm only here to say what was brought before me and the decision I made on that. That's all I.
Right. I went to inspect the house the other day, and I looked at some of the grievances, and particularly problems that existed. It looks like we're fighting over inches more than anything else. Yeah, I mean, that's how it appears to me. Most of the issues that were being fought about seem to be fighting over inches rather than major issues of nonconformity.
Mr. Norman?
I don't know, Mr. Budge is the right person to ask this, but I guess the question I have is, well, let me ask this question, Mr. Budge.
Sure.
I think you handed around a similar diagram to this one. So is this the site plan?
Yes.
That you guys have? Okay.
Now, that was for the September 5th, when
Right.
we made the findings of fact.
And it said on the, looks like the east side of the house,
Yes.
the setback is 4 feet 6 inches. Now that's from the property line to the house itself, but
Yes.
are the decks, where are they in relation to the setback?
There's some temporary decks now that will be, that you mentioned, that will be torn off. I can't speak to those, but
So what we're seeing in the picture, those are temporary?
no, those, on the right-hand side is what we approved, and they go back just not quite a quarter, maybe a third of the way of the building, and then they stop. They don't run the full length of the on the right-hand side, as you see, those stop. I wish we had that aerial view back.
And the front of that deck is at the setback that is listed in the...
Again, my setbacks that we did findings of fact were for the building. Decks never came before us as any kind of
So the
setback.
deck extends beyond what the line was when you got it approved by the designer.
The property line goes past that wall about 6 feet. Onto Rodney, down below, the points come 6 feet this direction from that wall there.
Are you looking on the side or the front or the base?
So I'm looking at the deck in front.
Okay.
Is it the building that is at the setback line,
Well,
or is the deck
okay,
at the
if you
setback?
look at this, there's 19 feet from the property line to the building on this side. So there's no problem on, this is the south side of the building. The side where the stairs is that face the street were 6 feet, and it should have been 10.
Mr. Chair?
Oh, I'm sorry, if I could kind of finish my question.
Just a minute.
Okay, so I just want to get clarification on this. I saw some issues with this. Maybe Mr. Scott can answer the building on one question. But another question I have to you, Mr. Bud, is in your experience on the design review board, how many new construction projects have you dealt with in Old Bisbee that are new construction?
Sir, I was on the DRB starting in 2002. I was there until I got elected on the city council at 2007. I was there until 2014, and then as the city council member, I was the liaison to the DRB. And then I got back on the DRB when I got off the office. So my history is almost 15 years, and after those 15 years, I could count the number of new homes on less than 2 hands. I would have to go back, but I can only think of maybe 6.
Okay. Yeah, that would be, I mean, that would make sense to me.
That would be
Like
brand
there's a
new.
lot of brand new from,
Very few brand new ones come before
a
us.
scraped lot to new construction.
Right.
There's probably not that
I can
many.
think
So,
of,
all right, thank you.
All right, we're kind of running on the time frame, and Mr. Sky is out, going to have an opportunity to conclude. Mr. Laird, do you have a,
Yeah, I do have a point of order. Mr.
Could you
Scott's
go to the
come back.
microphone,
Yes,
please?
thank you, sir.
and state what your concern is?
Yes, sir. Mr. Sky's come back, and before the witness leaves, I'd like to ask him just a few more questions, and I'd like to cede time out of my time to do that, because I don't want to prejudice Mr. Sky with that.
Time based on our questioning, so.
Without objection, that's fine.
Thanks.
Proceed.
Mr. Budge, Mr. Sky never submitted a site plan to the DRB or anywhere to the city of Bisbee that you know of, right, that showed where this building would sit on the property, right?
to be quite honest, I would have to go back and look at what was submitted to me on the second and third meeting. Well, it would have been the second meeting when we asked him to come back with the size and where it was. That was way back in May or whatever it was.
Okay.
I'm sorry, I can't answer that honestly without seeing the documentation.
Okay. And you do know that, that the notice that went out to neighbors specifically stated that there was going to be an addition to the south, which is the opposite direction that Mr. Sky actually built in, right?
What I do know is the original application that was brought to us said south. I don't know what went out to the neighbors. That's not part of the DRB's
Okay.
purview. It's what the staff.
Do you know that the Bisbee zoning code 5.3.4B requires that the alteration to an existing structure or of a proposed new structure shall adhere to the Secretary of Interior standards for treatment of historic properties with guidelines for preserving, rehabilitating, restoring, and reconstructing historic buildings?
Absolutely, that's what's in our code.
You understand that's controlling code for the DRB, right?
Yes.
Okay. And do you know that the Secretary of Interior's standards for rehabilitation include that the distinguishing original qualities or character of a building, structure, or site and its environment shall not be destroyed?
Yes, and one thing you have to consider from the DRB standpoint is we have contributing structures and non-contributing structures. Contributing structures are taken with a lot more care. This was a non-contributing structure, just so you know that.
I
It
understand.
doesn't change what the rules are, but that's one of the things we use in our deliberations. It's posted on every single agenda. This is a contributing or a non-contributing structure.
There are additional rules that apply to contributing structures, and that's not what we're talking about here, right?
Well, what we're talking about is from the National Park Service, which is Washington, D.C. standards, and that's for contributing structures.
Okay. All right. Do you understand, do you acknowledge that it says that in the event that replacement is necessary, the new material should match the old materials?
Okay, under the rules of National Park Service is additions, they would like to see that have a very different look than what the original was there, so people know that something was added, not necessarily made it look full old. That's the Park Service's recommendation.
How about for a whole new building like we've got here?
Well, they don't deal, none of the things from the National Park Service deal with brand new buildings. They just say, well, they do, in respect to size and scope and what will fit in with the district should be part of the district consideration.
It should look the same. The size, scope, it shouldn't
Yes.
alter or destroy the look of the original, correct?
Well, again, you're talking about, one minute you brought up new, now you're bringing up redo. I don't know which one are you referring to. New, not necessarily that it stays what it is, because there was never anything there, but yes, on additions, they like to say the additions should be a different kind of siding, something different totally, but we don't necessarily say that's...
Well, specifically what I'm talking about is what happened here in the case of replacement, where you're replacing an old structure. Yeah. In that case, it's supposed to not destroy the size, scope, look of the area, the neighborhood, the old structure that was there, right?
And as one of the things that came before us was the house just up the end of the street, which is a total wood house that was constructed and was shown as an example of what was in the neighborhood of what this was.
You've been up to Laundry Hill, right? Since many times. You know what's there now, right?
Yes.
You know that it's utterly changed the size, scope, look of what was there before, right?
There's a brand new house that looks like the house that's up at the end of the street, which is a total wood house plain, yes.
I'm talking about the vista that was there before. There was a small house. There were mountains in the background. You could see the cars going by on the highway, right?
Depends on where you're standing, yes.
Well, if you're standing right in front of it on Laundry Hill Road, that's what you saw before. And now what you see is a giant building that's new, right?
Well, I don't know how that protects to what we're talking about tonight, which is the September 5th. I'm feeling uncomfortable you're getting outside of the September 5th that we're here to hear. You're asking me?
That's all I had.
All right,
Thank you.
The board have questions following Mr. Laird's questions? Thank you, Mr. Budge.
Thank you.
Mr. Sky, I'll allow you a few minutes to make a concluding argument if you wish. If not, you can. You don't have to.
Why not?
All right, I'm not going to take much more of your time. All I want to say is that in the beginning of this whole thing, I really thought I was helping the neighborhood. I thought I was doing something great for Bisbee. I thought that I would be applauded and everyone would be like, hey, thank you for fixing houses in Bisbee. Didn't end up that way. I really just want to continue to live the rest of my life in Bisbee and my children. I'm trying to make a future for my family here. And like, what's your name, Peter? Like Peter had said before, we are literally fighting over inches. There's literally 13 feet in between my house and the Humphreys house. I believe I'm almost 70 feet away from the Laird's house, so I definitely don't affect them at all. They have their own parking that's way up the hill. They walk around to their house. They literally don't even have to look at my house if they don't want to. And I would just ask that you guys please take it easy on me. I'm just trying to do what I think's right for my town and my family, and that's it. Thank you.
Thank you. The board wish to take a recess?
Yes.
All right. We will go into recess. Let's take a 10-minute recess, and we'll reconvene in 10 minutes. Let me remind you, please don't attempt to talk to the board members. We'll be in recess. Sky property. The records show the parties are both present. Mr. Laird, do you wish to present your testimony?
I would.
Okay. Please raise your right hand.
Yes, sir.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Would you state your name, spell your last name, please?
My name is Brian Andrew Laird. Last name is Laird.
Thank you.
Thank you. So I'm going to talk a little bit, and then I'm going to call a witness who is the surveyor that we had go out to the place to look at the encroachments. And that surveyor, by the way, you all were given a survey map by the city today. The surveyor I'm calling as a witness happens to be the guy who did that survey. So same one who the city relied on. First thing I want to point you to, and I had these slides and we presented them, and I don't know if you got paper or not. I think maybe people don't have them in paper, and it may be a little hard to see, and I apologize for that, but I'm just going to go over this. The Bisbee zoning code, which we talked about a little bit earlier, says that for a new single-family residential structure or accessory building, the front setback is not less than 10 feet, and the side setback is not less than 5, and the rear setback is not less than 10. We heard that earlier. Mr. Budge testified about an exception to that, and that is 5.3.2B1. And then if you go down to number 3, and it says for renovations, repairs, and additions to existing single-family residential structures, you shall not reduce the existing setbacks to less than what is required for a new structure or to what's there, unless the board finds it's not going to impact the neighborhood. Okay? Now, the board did, when we brought that to their attention at the hearing, make that finding of fact. They said, well, it's not going to affect the neighborhood. The problem with that is that number 3 there does not apply to new residential construction. And it's undisputed at this hearing. We've heard from Mr. Sky that this is a new home from the ground up. When you build a new home from the ground up, under the zoning code, you have to have 10 feet front and back and 5 feet on each side, and there isn't an exception. There is not a finding that the Design Review Board can make that says we're going to waive that. And if you look at the number 5, I think it is, of the documents that I provided to, I'm sorry, it's item number 3. That's the Arizona revised statute that controls you folks, your role. A Board of Adjustment is authorized by the state of Arizona, and the state of Arizona has drafted law, passed the law through the legislature. It was signed by the governor, and that's what we live with. And if people don't like the law, then people need to change the law. But the law applies to everybody. And what ARS, Arizona Revised Statutes, Section 9-462.06 says specifically about your jobs, the jobs you've been given authority to do, is that a Board of Adjustment may not grant a variance if the special circumstances or circumstance applicable to the property are self-imposed by the homeowner. And this is exactly what that law means. It means that if you come in and you're going to build a new building on a plot of land, you need to find out what the setbacks are. You need to do a site plan. That's why that rule exists, which Mr. Sky unfortunately did not comply with. He never did a site plan if he'd done one. And it's an unfortunate way to learn a lesson, but if he'd done one, he'd have seen, hey, the setbacks are not met. What you're going to see in a minute is that the setbacks, he was going to be in real big trouble either way, because in fact this building encroaches both at the front and just a little bit at the back. So the building itself is simply too big for this lot size. You cannot fit it into this size of lot, okay? Number 3A in the materials I gave you talks about what a special circumstance is, and just so you don't get confused, a special circumstance effectively means, according to the Court of Appeals, the courts of appeals in Arizona, a hardship. That is something that's difficult for a homeowner or for somebody who's building a home. And what the law says very clearly and repeatedly is that just because it's difficult for you to build within the confines of the setback requirements, that's not enough. And if you go and build outside those requirements, that's a self-imposed hardship. That's something you did to yourself. Again, is it a great thing? No, it's an unfortunate thing. But it is the law. It would have been much preferable that Mr. Sky, and at the instruction or direction, whatever it was, of Mr. Ward and the Design Review Board, had actually done what's required. And it's required of people all the time. People come into the Design Review Board and they submit plans prepared by architects, and they meet every single requirement, and they still have to jump a little bit to get things done. Those rules, that has to be applied evenly. It's not just, I grew up here, I was born here, and therefore I get a pass, okay? We all live in the same state and under the same laws. With that, I'd like to call Steve Sample as a witness.
Just a minute, Mr. Laird.
Yes, sir.
I think it'd make more sense for you to
I'm
finish
jumping,
your
just-
testimony, allow Mr. Sky to cross, basically, and do that. Return your seat, sir.
Can I interrupt, and maybe we can ask Mr. Sky? The way that I intend to do this, and Mr. Sample's been sitting here for a long time, is I'm going to ask him questions, and then I'm going to continue and make the rest of the presentation myself. So if Mr. Sky would like to wait
Mr.
and
Sky may
answer...
have questions, and the board may have questions of the surveyor also.
Correct.
So let's do it just, you know what he's going to testify to.
Sure.
So basically, you can just go ahead and present your case, and then the questions will be asked by Mr. Sky and the board, and
You
then
bet.
we'll call the surveyor.
Okay, so you want me to stand over there for Mr. Sky to question me, or what are we doing?
I don't think it matters where the microphones are.
Okay.
Are you finished with your?
Oh, I'm not. Okay. What, I intend to address many other issues not limited to the survey. I had hoped to address just this survey and then let the surveyor go as a witness and then go on.
I want to keep the structure going, and I mentioned basically you can deal with the survey. Basically, we've got 3 issues. You can talk about those issues and go from
All right.
there.
And what I'm understanding you to say is that you would like me to continue with all that I'm going to present, and then cross-examination, then we'll go to my witness. Is that right?
Yes.
Okay, good. Terrific. If you, so if we move forward here, my friend.
You have it. Yes.
It is on.
Can I do it with the mouse? What do I do?
Just roll it up here.
Okay.
Okay, good.
Great. All right, this is the revised statute that I told you about, and this is the Arizona case law that I told you about. So I'll go past them. That's the original structure from Google Maps. You've seen a current image in the city's materials. You can see the Humphreys house up here. The original structure ended right at the end of the road. It was obviously a dilapidated building. If it could have been saved, I don't know. There are specific rules about demolition, however, and if you're going to demolish a building, you need to go through the process to do it, to replace it with a new one. Mr. Sky, in his initial application, stated that he was building an addition on this structure to the south. That's to the south. Instead, what he did was he built, as you've seen in other photos, to the north, there. This is another aerial view, and it shows you in red, this is the original building. The roof line ran east to west, you can see that. The yellow dotted line is the outline of the new building that was brought in, built to replace the little house that was there before. The yellow that is solid is where the decks are. So all of that yellow together is the mass that replaced this little building there. That's a view of Mrs. Kendrick's house. This is obviously before work was ever done. This is the siding that was actually finally applied to the new structure. So would point out that that siding was there, ready, in place, before the old building was demolished. This is Mr. Sky's initial design review board application, in which he says he is adding an addition on the south side, then copying the bottom footprint. That's simply not what happened. Mr. Sky said to you, dyslexia, I didn't know which way was north, I didn't know which way was south. It's just something that happened. This is a drawing from Mr. Sky's initial application. It's a drawing he did of what he was going to build there. Up in the top, it says, and I can't read it very well from here, without my glasses. So I will tell you that it says south-facing side of house, and then in parentheses, it says Tombstone Canyon. So when Mr. Sky testified to you that he didn't know which direction was south when he submitted his plans, that's not a credible statement. His own document that he submitted in his initial application to the review board indicates very clearly that he knew which direction was south, the direction he was applying to build in with the addition. He wasn't going to build up into the neighborhood. He wasn't going to build up next to the Humphreys home and crowd it all with that. He was going to build down toward Tombstone Canyon. The next page here is the letter that went out to neighbors. And if you look at the third line, it says the application is seeking approval to build an addition on the south side. And that is all the notice that neighbors ever got. No one in the neighborhood ever got notice that there was going to be an addition on the north side of the structure, which is a huge material impact to the neighborhood, to the look, to the feel of the top of Laundry Hill. And again, you have to look at the idea of whether this is a self-imposed hardship or not. So when you are building a structure and you're applying to build to the south, and you're saying, I'm going to build away from the neighborhood to Tombstone Canyon, if you then alter your plan and decide, no, I'm going to build to the north 17 feet, it's plain that that's going to have a big impact. It's incumbent on you, if you're going to make that impact on a neighborhood, to know what the setbacks are, to know what those legal requirements are, and to abide by them. And if you don't, then the hardship that you find yourself in is self-imposed. The next document is and this is my document number 8, is 3 pages, which are Mr. Sky's demolition permit applications. And if you look at those documents, they're in the materials we gave you, this was originally filled out on April 1st, 2018. That's at the time of the original DRB application. It's before the hearing, the first hearing, it's before the second hearing, obviously many months before the third hearing. And he's asking not to do a reconstruction, a remodel, a renovation. And that's what he told the DRB. That's what he went to the DRB and said was going on. But what he asked for was project description, demolition, and cleanup. And it was dated on April 1st, and it was stamped by the city on April 19th. And the next page confirms it again, and this is in Mr. Sky's own handwriting. Again, it says demo and cleanup, interior work, and exterior work. So it's clear from the start, Mr. Sky had brought in materials that ultimately were used for his new building. He applied for a demolition permit at the start. He then demolished what was there. The next page, the second page after that. So this is another page out of Mr. Sky's Design Review Board application. And on the left there, you see the existing home. That's the Humphreys home. And so this is what you're submitting to the Design Review Board and the packet that's made available to the public, and that you're representing to people, this is the impact that this is going to have on your neighborhood. I'm showing you a drawing so you will know what this looks like. And what he submitted showed the Humphrey home ending here, there being stairs right after the Humphrey home, and that then beyond those stairs would be this new large building. Well, that's what it would have looked like if he had built to the south, away from the neighborhood. It's not what it was built to be. This shows that same, that's the Humphreys property line there. There it is right there, same line. So instead of his building being back away from the neighborhood, built away from the neighborhood, it's built up into the neighborhood. It closes this whole area off. It also, in his pictures, can't see it well in this one, but if you look in the packet, it's there. He represents it as being below, and he said this at the Design Review Board hearing, below the Humphreys roof line. But that's not, in fact, what happened. It towers above the Humphreys roof line. Lost that. Thank you, Sam. Thank you. So that's basically what I have on this being a self-imposed hardship. It's plainly in violation of the zoning code. The Arizona revised statutes don't give you liberty to not enforce the law in this circumstance. The statute says, it doesn't say the board should not, it doesn't say the board may not accept in certain circumstances. The Arizona revised statute that's applicable says a board of adjustment may not grant a variance when somebody has a self-imposed hardship. That's what we've got here. The next thing I want to talk about then is the issue of the design review guidelines and the windows and doors. And I'll make that very quick because I've put written material in front of you. But the bottom line is this. The design review guidelines, in essence, say you're not supposed to destroy the look, the feel of any neighborhood, any property in the historic district. That is what happened here, is happening here, will happen here. You're supposed to replace architectural elements and features only if absolutely necessary. The guidelines also provide some pictures. These are windows. All of those, it's actually kind of handy because they say yes, 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 yes for things that you should look for and say, does it look like that? And then they say no to other appearances. Same thing with doors. These are all yeses. These are no's. This is a no. Does that building look familiar to you? That's a no. As far as not changing the look and the feel of the neighborhood, that was the view standing on Laundry Hill. That's what we had to look at when we pulled down the slope. The mountains in the background, at night, the lights on the highway. And that's what you see now. And it has utterly changed the look, the feel. These windows, I don't know if the board received the audio of the original hearing, but essentially at the Design Review Board hearing, a board on which Mr. Sky is a member, Mr. Budge and others, I don't remember the specific people that said it, but essentially said, tell us what you want, John, when it came to windows and what he was asking for. And it was not limited to, I understand that the application says that this was just about the placement of windows. But it was not limited to that, because what Mr. Sky said was, well, I got a great deal on some windows, and so I went ahead and bought them. And you're looking at them. And that's not anything that fits within the design guidelines. These are white, sort of Pella style, maybe they are Pella, I don't know, vinyl windows. and they look nothing like the original structure. Same thing for the doors and windows on this side. These are massive, massive picture windows. There is nothing in the design guidelines that for a minute says that you can do that. These are brand new doors, you know, that have no appearance of Old Bisbee whatsoever. One reason that what you decide today is important is this is Mr. Sky's vision of the future of Bisbee. So those are this. And that's what he wants to do. And I'll tell you something else. When it comes to these things, the law applies equally to everyone. So if Mr. Sky gets to go to the design review board without submitting site plans, without submitting proper exterior plans, without ever identifying what the setback requirements will be, and complying with them, then everybody else who wants to buy a lot gets to do that too. Because the guidelines apply to everybody equally. And it's important that they be applied equally. With that, I'll submit to questioning, and then I'll call my witness, if it's okay with you.
Mr. Sky. Mr. Sky, do you have questions you wish to ask Mr. Laird?
Yeah, for sure. All right, can we just flip back to the beginning of the pictures that we're going through?
I'm going to let him.
Can you be more specific?
Stand here. From the beginning of the PowerPoints, if you could just go back to the very beginning, and we'll just go through. Okay, the setbacks. I've maintained my setbacks on all sides except for the back towards the parking, which is at 6 feet.
You want to ask him questions about his testimony?
Okay. All right. Let me get back here. All right. So the setbacks that you're concerned with, you were mentioning the south side.
The setback problem that you have is on the north side, and for the building is on the north side and on the east side. There is also a small encroachment to the south towards Tombstone Canyon. So you have about 4.5 feet to the north that you encroached, and then you have about less than a foot in the southeast corner of the building.
All right. Well, there's actually I had an email sent to Paula Esparza about the property.
Just ask questions.
Okay, just questions. Okay, do you know how far your parents' garage is from Susan's property line? Do you know how many feet that is?
I have not put a tape measure on it. I do know that when the garage was built, it was submitted to the design review board, the city. There was a discussion about the garage, and ultimately it was approved and it was built.
And would you say, could you tell me what year that was built?
I don't know your.
Okay, was it built recently, within the last 10 years?
You know, I hate to guess, but I'd say a little more than 10 years ago.
Okay. I did put a tape measure on it. That's 3 feet.
I only prepared to answer questions about your
Okay,
structure.
that's fine. And then, do you know how far your property line is from the Humphreys residence?
I think it's approximately 70 feet, but I only assess that by eye. and I've never put a tape measure on it.
So you'd say that from the door on the other side of the sidewalk to the Humphreys residence that's on the other side of the sidewalk is 70 feet?
I'd say it's approximately 70 feet from our property line to your property line.
Oh, no, I'm asking from your property line to the Humphreys property line.
No, don't know.
Okay, 37 inches. And then, do you know
Which door?
how, it's the back door that you walk into from the sidewalk.
Okay.
Do you know how
That
far-
part of the house that part of the house was built probably in the 40s, but maybe before that.
Mhm.
And it was certainly before the adoption of the design review guidelines and the current Bisbee code.
Okay. And do you know how far your property line is from the Eaton property line?
Same answer. No.
28 inches.
Again, you're talking about the old miner's cabin portion of our property.
Well, I believe it's all relative because that's how the whole hill's built. So that's what I'm getting at, in case you're wondering. And then, let's see. And you're saying that my property is about 70 feet from your property?
I believe that the property line, if you are standing at our gate, or rather at the fence, that is next to the mural, it's on the wall there, is approximately 70 feet from your property line that is beyond the Humphreys property line, not the property line that's down Canyon to the south.
Okay.
Okay?
Let me ask you, do you know how far your brand new addition, the bathroom that you guys built in the back, how far the side of your building is to the property line to the east?
Don't know.
It's 4 feet.
Okay.
So, you're a little off on how far your house is, but it's more like 68 feet to your fence from my property.
Well, I was doing that by eye.
So let me ask you this. So when you come to your parents' house, how do you normally, when you come down Adams, explain to me how you normally come to get to the front door. If you could walk me through how you get to your front door of your parents' house.
Go in the garage, either come back out the garage door, or you go out through the door that's in the garage, and you walk down the stairs to the back door of the house.
Okay, so at any point in time, do you park in that big open spot that's down there in front of my house and by the Humphreys and by, do you go down there at all?
I do not know whether I've ever parked down there. If there are more than 2 visitors, that's always been a place that people have parked, but it's my understanding that you've now purchased parking down there, and we certainly won't be parking on that one.
Okay, so what you're saying is there's a garage door in the front, and then there's a side door on the right facing south, correct?
Yes.
Okay, so you walk down to the city walkway that's in between your house, Janet's house, or the Eaton's house and the Humphreys' house, and then you take a left going east, and then you enter your home to the north, correct?
My understanding is that we own the walkway that goes down to our door. In
Well-
fact, the stairs used to go right where your house has been
Yeah.
built.
Well, let me give you a little
And we-
history
and we allow-
lesson on that.
And we don't object to people walking up the walkway at our property.
So Helen, when she built the deck going out in the front, that's when the city changed the easement, and your mother, from my understanding, agreed to let them go up that sidewalk that Mr. Smith's father had built, and then cut through in between your new garage and the Eaton residence.
Well,
And now there's no more easement going through there because of that porch. So technically, in between my house and the Humphreys house is, it's not a public walkway.
Well, you know, John, we're not going to restrict people from walking on that sidewalk anyway. I'm not sure if you understand that if there is a property ownership, like an easement, it has to be recorded. And the records that I've seen show that that's part of our law. But frankly, it is not, it's certainly not important in any way to what we're here about today.
Okay. Thank you for saying that, because I've been wanting to say that all night. Okay, so your major gripe is the 10-foot setback in the towards the parking that doesn't affect you whatsoever. And in this, it does say in the paperwork that you put forward, it says that they can make variances on the front and the back. So I don't know if you read the same thing that I read, but I think Mr. Budge explained it, and then he just came back and reiterated it.
The answer to that is that the section of code you're referring to is not applicable to new buildings such as yours. So they cannot make that determination for a new construction like the one that you did.
All right, so one more question.
Sure.
Would you agree that all the houses up there are built on or beyond property lines?
I agree that most of the houses up there were built quite some time ago, and I would agree that the size of the building that you built, which is about 29 feet above grade, although you're limited to 26 feet above grade, and you have massively built into the setback, has completely changed the look of the neighborhood. And you know, you've said, and other people have said before, well, look at what was there. You know, isn't this better? And I'm sorry, John, but the answer is no.
Do you feel that's an opinion, or do you think that's a fact?
No, that's my opinion.
Oh, okay. And then I wanted to go back to the drawing that I submitted because I was basically being called a liar. So I'd like to go back to that. It's just the pencil drawing. So at any point in time, where did you get the notion that that was my drawing?
All right, Mr. Sky, you may make your conclusion.
Okay. And thank you all for being here tonight and dealing with me. I know it's not always easy. So what I would like to say is that the front of the house, the reason why it's where it's at is because that's where the front of the other house was. And the side of the house, the reason why it's there is because that's the side of where the other house was, the old house. I did intend to integrate that into the house. It didn't work out. I lost. But I did build a beautiful home up there. It appraised at $314,000. It brings up the property value for everybody up there. And the other thing that I would like to say is that I just hope that, you know, I believe that I did everything that I could to follow within the confines of the law as I knew it. I really tried my hardest. I'm not the smartest guy. I'm not the best builder. I'm not really the best at anything. But at least I'm trying. And I feel like I succeeded in what I did. And the house is done. I got my final inspection. Literally, me and my family are like ready to start utilizing this house. So, you know, the other thing that happens when you're building is not everything comes out exactly the way you plan. And I did try to make the 5 feet thing, and that was on the side of the house, but it didn't work out that way. And then when I had to add all the fire, you know, the fire protection and all that, that really brought it back out. And then there was a lot of different things that happened during this build, and I did my best. And I just hope that I can continue to live freely as a citizen of this town and keep contributing as much as I can. And that's all. Thank you very much.
Thank you. Mr. Laird, you may make your conclusion.
Yes, and I'll keep it brief too. And I feel the same way. I'd like Mr. Sky to continue contributing to the community as well. It's important that there's one rule of law for everybody. I think it's great that we get to come in here, we get to appeal these issues, we get to be heard, both sides equally and evenly. There's a reason that that statue, you know, with the scales, has a blindfold on, and it's because just because you went to law school and have that advantage doesn't mean that you have any more of a right than Mr. Sky does or anybody else does. You folks need to make the decision regardless of that, regardless of who I am, who Mr. Sky is. This is not about what we call the equities. It's about the application of the rule of law. And I very much wish Mr. Sky had done things correctly, that he'd submitted a site plan, that he had built the building properly. We wouldn't be here today if things had been done right. And that's a tough lesson to learn. But as hard as it may be, you still have to apply the law to what happened here. That's all I have. Thanks.
Thank you. That concludes our accepting of witness testimony and exhibits. And now we move to discussion among the issues of the board meeting. Basically, we have 3 issues before us. And what we will do is have a motion from the board either to affirm, reverse, or modify the action of the DRB in each of the 3 matters that are being appealed. So we're going to have 3 separate votes. Okay. So the board will entertain a motion to affirm, reverse, or modify the action of the DRB in granting an exception to Mr. Sky regarding a window placement due to an interior wall change.
I'll second that.
No? Someone needs to make a motion.
What is the exact issue? Which window? It says a window is all window placements in
There is one window replacement, or placement as I understood from the materials that we were given. Yeah, that was in the, I can't recall which side of the house.
Is this the picture window on the back side of the home?
Yes. I need a motion to affirm, reverse, or modify.
I move that we affirm the window placement, approval of the window placement.
Is there a second? Is there discussion?
If the window is that objectionable, I just wouldn't.
This is Mike. You can't hear anything.
It's the placement of the window we're talking about, not the design of the window. Is that correct?
Well, as far as the placement, I don't see that as an issue, but it was a design issue or protocols.
Yeah.
And certainly some cosmetic things can be done to the window to make it look as if it was segmented or squared out, and that should handle the cosmetic issues and disputes over the window.
Other comments?
Well, if we believe that there's anything that needs to be changed, that the window should not have been approved by the design review board, then we shouldn't accept their decision. So, I mean, you know, and whether we accept it or reject it, it's not going to change the window. That becomes a civil matter between the parties based on our decision.
Well, I may be wrong, but I disagree with that. I think if we deny, if we say that we don't accept what the DRB did in terms of approving the window, that Mr. Sky potentially would be required to correct that, to take the window out and replace it with something else. But is that correct?
Don't we have the power to reverse or approve, but no power to issue guidance as to what would happen after that fact?
As I understand the rule, basically, we have authority to order a modification. Is that right, Attorney?
Yes, the power of the Board of Adjustment is to affirm, reverse, or modify a decision of the DRB. I don't believe that that is suggesting changes to some design structure. I don't think that's at all what's intended by the word modify.
Oh, I would move to accept.
Well, we already have a motion on the floor,
Yes.
and it's been seconded, so we need to vote on, there's been a motion to accept, and so we need to vote on that. We either need to approve it or deny it. If we did, if we don't approve it, then there needs to be a new motion.
I'd make a couple comments that basically, it's addressed at all three of these issues, essentially. I'm going to rely heavily on the experience of the Design Review Board. I mean, they do dozens of these and have for many, many years. I think it's important that Mr. Sky, as I understand it, basically followed the directions of the Design Review Board. I would disagree with Mr. Laird as far as whether this is a self-imposed injury. I think a self-imposed injury would be going off and doing something without the approval of the Design Review Board. And having that approval, I think he certainly felt justified in doing so. And I think, we can, I think, and I'm not sure the order of this, but we can order, for instance, at a certain time, Mr. Sky remove that temporary deck within so many days, or refer it to the zoning officer to see that that is completed. So those are my comments in general, but we have a motion before us is to affirm basically the action of the Design Review Board in granting an exception to Mr. Sky regarding the window placement. The code requires basically a concurrent vote, which means all in favor of the motion indicate so by saying aye.
Aye.
Opposed?
Nay.
The motion passes. Next, Chair will entertain a motion to affirm, reverse, or modify the action of the DRB in granting an exception to Mr. Sky regarding the addition of an external staircase which was added to the building. Do I have a motion to approve or affirm, reverse?
Does that include the temporary? I mean, I'm getting all mixed up in my directions. This is the rear staircase.
This is the rear staircase.
Not the side.
It's not the side. Is there a motion to affirm or reverse?
Motion to affirm.
Is there a second?
I'll second.
Are there any comments, discussions?
Well, I think, and we didn't spend a lot of time talking about it, the staircase, I mean, based on Mr. Sky's testimony, he was directed to put the staircase on there to provide access to the second floor for fire code or safety issues. I don't know that there was evidence presented to verify that. But I think the concern I would have, and I understand that there's documentation in the file that that this structure is intended to be a single-family residence, and that staircase is required at the direction of the city for fire access or access. So that this structure not become a duplex or anything. So that I think that's not what we're deciding here tonight, but it's a comment that I want to put into the record. I don't have a problem with the staircase, but I just wanted the record that the understanding is that this is a single-family house. That's what was represented here, and would be expected that that's what we're basing our decision on.
Other comments?
Well, he was directed to put that there. I would also suggest, Mr. Sky, unify those properties. Then that issue kind of goes away.
I would
So,
agree.
I mean, that would be an easy solution.
I think that's an excellent point. He did purchase the additional right-of-way on the street, which could address some of the setback issue. And again, as Mr. Patterson pointed out, that is still a separate parcel. They need to be joined to the parcel that the house is built on. And that should be required.
No comments? Hearing none, all in favor of the motion indicate so by saying aye. Opposed? Nay. Hearing none, the motion passes. Third issue is there a motion to affirm, reverse, or modify the action of the DRB in granting an exception to Mr. Sky regarding the reduced setback on the size of the home?
I move that we discuss modification.
Is there a second?
Second.
Other comments? Yes.
I just want to say that after hearing all the testimony and everybody tonight, I feel like latitudes have been taken in all areas where this property is concerned. I don't believe anybody is guilty or not guilty. I am most likely going to side with the Design and Review Board. However, I do think at some point we need to put some other protections into place.
I would agree. I think from what I've read in the documents that were provided, what we've heard here tonight is that there's been some breakdowns, process failures, process disconnects throughout this whole construction project. And what's unfortunate is that early on, those things weren't corrected when they could have been. I think that adequate information wasn't provided to the Design Review Board, but I think it was incumbent upon them to insist that it was. So I think that's a lesson learned. Concern I have for Bisbee is that Bisbee is being discovered. People are moving here. As Mr. Sky mentioned, what his house was appraised at, property values are going up. So there's going to be a lot of other people coming here from other places, from out of state, from bigger cities, looking to redevelop parcels. So the Design Review Board, the city has to be on top of their game when it comes to dealing with people that are going to come here. Some of them will be very experienced and very savvy, others won't. Some protections need to be put into place, some processes, and they need to be followed. And when information isn't provided, that needs to be provided to protect the integrity and safety of the community. The bodies charged with that need to be firm about requiring that. And I don't think that happened here, and that's why we're here tonight.
Well, I also want to say that just if the Design and Review Board approved the staircase, that doesn't make it automatically okay, because we're looking at that decision ourselves to see if it was a correct decision. So we can't use the decision to affirm itself because they made it. The other thing I want to say is we go beyond the Design and Review Board. He's been issued a certificate of occupancy. So how do you get to that point without, if that's what he states, how do you get to that point without anybody approving any of this? I mean, we've gone beyond the review board. So, I mean, it's something that
Right.
I agree with you.
And then we're on the, we already decided on the staircase, but this is on the setbacks. And I think my motion was to modify.
I second
DRB
that.
And second, okay. So, again, I'm not sure how to modify it, other than,
Wait, I'm back.
oh,
We had a motion on the floor, right?
Right.
To affirm.
No, to
No,
modify.
Modify.
to modify,
We didn't have a motion prior.
No.
no. No,
Yeah, the first motion was a motion to modify
the setbacks, or the
Setbacks.
decision on the setbacks.
Right.
I just put that out there so we could have some discussion on it, and it was seconded by Mr. Patterson.
And I misunderstood.
So we can
Is there any
vote.
more comment on the motion?
Well, I think some of this can be taken care of by removal and modification modification of the staircase. But you can't move the building, but.
You already made a motion, this
Then we're
decided a
discussing
motion
it
on the
now.
staircase.
Correct, correct.
No.
And this doesn't have any.
We're just dealing with the setback now.
Mm.
Yeah, and the staircases affect setback as well. Because there are other setback requirements, the 2-foot setback on the staircase. So, one can affect the
The
other.
motion was to address
Well,
the
the motion
setbacks
is
on the
regarding the
sides of the
setbacks,
house.
either we
They already voted on the
affirm,
staircase
reverse,
part.
or modify. Or you were saying
Setback was
for discussion for modify.
And again, I want to put that out there, I don't know what you do to modify it, and basically it's to
They
say,
voted to keep
are there
the
some
staircase.
things, like, again, that deck that was built, and Mr. Sky said it was a temporary deck, that will need to be
They did
removed.
decide the staircase, though.
Now that the construction is complete, I'm assuming, you know, if it's not on his property, that's kind of an easy one, that needs to be removed. The setback to the north, where the staircase is, I don't know, Mr. Sky, I think as Mr. Patterson said, Mr. Sky did purchase that additional property, I don't know if that addresses or provides him with the setback that's needed, but.
Mr. Chairman?
And then the other concern I have is on the east side, where the deck is built right to the property line. That's a concern. I want to say that setback, the underlying zoning, the setbacks were ignored, and that's not acceptable going forward. Setbacks are there for a reason. So, but again, Mr. Sky his plan was approved by the DRB, was signed off by the city at various points during construction, and then he's been given a final certificate. So basically, he was proceeding under the assumption that he had approval. And that's, the city should have, or the DRB, again, there was not proper information provided from the get-go, and that should have been corrected upfront. And I don't know, part of the modification or what we're approving is saying the city, maybe by a date certain, needs to update their DRB review process, update their design codes, that sort of thing.
If we modify this, then what we're saying is that we want to change the design and review board. We're saying that we need to modify what their suggestion was.
And I'm not
If
sure.
we don't know how to modify it, then we would be better off just denying it. And then letting the civil issue take place of it. I mean, there's no doubt that there's encroachment.
Right.
And that encroachment, we're told, was approved by the design and review board. Do we believe that was a correct approval? I don't know that we can't ask him to modify the building without moving the building or tearing it down.
Right, and I think
I
that's.
think we'd be better off rejecting the modification and make a motion to deny.
Well, I mean, basically to deny, or we can affirm, we can
You can
deny.
affirm, reverse,
Deny,
or
reverse.
modify.
So to reverse the setback approval is, it's like, well, how are you going to move the building? I mean,
Well, that's not our
prac-
problem.
Well,
It
but
really
again,
isn't.
the practicality of it is not feasible. And I know we can sit up here and say it's not our problem, but it's not a practical approach. And I think, yes, errors were made all along the way. And I don't think we should say, oh, well, you know, it's easier to ask forgiveness than permission because we don't want to set that precedent. But I guess I'm not knowledgeable enough to know how to address the setback issue short of moving a building that's already been built, that he had approval to build.
I would suggest you withdraw your motion to modify and make a new motion to deny or to reverse.
No, I think we can call the question unmodified.
Okay.
I won't withdraw.
Mr. Chair, if I might jump in, I believe that the motion was a motion to discuss modification of setback decision. And that actually is a little different than a motion to modify the DRB decision. And if a motion to modify the Design and Review Board decision is going to be made, the modification needs to be part of the motion, that whatever that suggested modification is.
Well, we've already discussed it. You want to just withdraw from the motion?
No, I'm going to try this again. Can the modification be to direct the city and the parties involved to come up with a proposal of how the setback issues could be addressed?
No. First, if you're going to amend your motion, you need to amend your motion. I believe our best move forward right now would be to deny this motion and then either affirm, reverse, or modify. If we think it needs to be modified, we don't know how to do that, we'd be better off reversing it and let the parties decide amongst themselves. That's my opinion.
We have a vote then on the motion to discuss, essentially.
Which we've already done.
Discuss it. Again, I put the motion out there so we could have discussion. Because you can't have discussion unless you have a motion.
Well, you usually have a motion, then you have discussion.
Right,
Basically.
and that's why my motion was to modify. And then so that we could have a discussion about how we might be able to modify it. If we can't modify it, then, or if we don't think we can modify it.
I'm sorry to be confused about this, but our attorney says the motion was to discuss modification, it wasn't to modify.
I will withdraw my motion.
Okay. Now, on modification, if we want to make a motion to modify, then we need to know what we're going to modify, how we're going to modify it, and to what the directive would be. I believe it would be better to reverse their decision and then either send it back to the Design and Review Board or let the parties decide amongst themselves how they're going to settle that. I think we should either affirm or reverse. And I don't think we don't have, unless we want to table this, we don't have the information we need to decide how we're going to modify or ask a modification to be made.
What's the pleasure of the board?
I move we reverse the decision on the reduced setbacks in north and east.
Is there a second?
Somebody else?
Hearing none, the motion dies for lack of a second. We have another motion.
Would it be appropriate to go into executive session and consult legal counsel on process?
We could table this one item to the next meeting. Is that correct or not?
I believe that the option to table a decision or to continue this hearing is really what that would be for the purpose of receiving additional evidence or information. I think because the information and evidence is closed and no one has indicated they need to study the materials some more or look at something, I don't believe that continuing or tabling is appropriate at this time. Going into an executive session for purposes of receiving legal advice as to the process that we're facing tonight, I think is appropriate.
Well, it seems to me that executive session would not be appropriate. Basically, what we need is more information, more facts, basically, as to what both parties would recommend as far as a modification at all.
And then, Mr. Chair, perhaps the motion would be to reopen the evidentiary part of the hearing and to specifically ask for that information.
Would the parties be prepared to go forward with that?
Mr. Chair, I guess we could, if a motion was made and entertained to do that, then the parties said that they needed additional time. It would be up to the board to consider giving that.
It's a pleasure of the board.
I move we go into executive session.
What?
That we go into executive session for legal process advice.
the side
Right.
corner. That would be the easiest way of doing that.
All in favor of the motion indicate so by saying aye.
Aye.
Opposed? Okay, motion passes. We enter executive session. I can't tell you how long it's going to last. So we need to recess to another room. Close executive session.
So, second.
Any discussion? Hearing none, all in favor indicate so by saying aye.
Aye.
Opposed, nay. Executive session is closed. We're going to reopen our general session. Basically, we have one other issue to resolve, and that is the issue regarding reduced setback. We have a motion to affirm, reverse, or modify the decision of the design review.
I move we affirm the design review board's decision to allow the reduced building setbacks in the north of east.
Is there a second? Any discussion?
In reviewing 5.3 of the Historic Preservation Overlay Zone, 5.3.2B, 2 and 3, and I read, in those areas in which established rear setbacks for the existing developed properties within the same adjacent blocks that are greater or less than 10 feet, the design review board may increase or decrease the front and rear setback for new structures as necessary to maintain the uniform characteristics of that particular street frontage. And 3, renovations, repairs, and additions to existing single-family residential structures, accessory structures shall not reduce the existing setbacks to less than what is required for new residential structures or less than what currently exists, whichever is the lesser distance, unless the design review board makes a specific finding that this construction will be consistent with the uniform characteristics of any of the adjacent properties, and that any such reduction will not adversely impact adjacent properties. From the testimony we received, the other properties are sufficiently close to each other that this property is not inconsistent, I don't believe, with the way the properties in the neighborhood are constructed.
Are there other comments? I would just add one in addition to the things I said earlier, is that we didn't hear from the Humphreys here. The Humphreys are the property that's right closest, and I would think they would be the most egregiously offended if that were the case. I think it would have been interesting to hear what they have to say. You know. But they're not here, and there's nothing to consider about that. So, are there other comments before we take a vote? All in favor of the motion indicate so by saying aye.
Aye.
Opposed, nay. Motion passes unanimously. That pretty much concludes our business. I want to thank the parties for their presentation and their demeanor during the hearing. This was a first for us, so you have to bear with us as far as how things were going. But again, appreciate you being here. And I'll order that the meeting be adjourned.
Thank you, guys.